Good morning, folks. Yes, you finally get another one in the morning. It's been a rough couple of days. Not just because I'm sick, but also because, with Valentine's Day and all the shit that comes with having, a second grade student around Valentine's Day. Valentine's Day. Did you see that my Mexican came out there for a second? It's Valentine's. So I was reading this horse shit Denny motion that Kratz filed. Now, see, I've heard some people say that a Denny motion is it's standard operational procedure in Wisconsin. That's actually erroneous information, folks. In order for the whole no inference of third-party liability bullshit to take effect, the prosecution has to file what is called a Denny motion. Effectively, this is a motion to suppress any evidence of third-party liability. And this document is so fucking slimy, I didn't even bother trying to print it up because I just knew that the ink would run off the page. Now, I am extremely disturbed by this document, and the reason why I'm extremely disturbed by this document is it's just... Well, first of all, it was prepared by Kratz. That right there should tell you how much horse shit we're dealing with here, folks. Second of all, who the fuck came up with the idea that this was in any way a good idea to do for the defense of a case? When you are defending or when you are prosecuting a fucking murder trial, if there's even a shred of possibility of third-party liability of somebody else having done this, that speaks to reasonable doubt, which is effectively what the defense is trying to do. The burden of proof is on the fucking prosecution. So who the fuck invented this Denny motion bullshit is what I want to know. So Kratz filed this on June 15th of 2006, and it basically states, the state of Wisconsin by Special Prosecutor Kenneth Kratz moves the court for the following orders. Number 1, accept as authorized by the court for an order prohibiting the defendant from arguing or otherwise introducing any evidence or inference that third parties other than Stephen Avery or co-defendant Brendan Dassey are responsible for the intentional homicide of the victim Teresa Halbach. Kratz, why would you feel the need to file this unless you already fucking knew, you were worried that by not filing this, they could bring up some evidence that would show that you railroaded him, that you didn't investigate this case at all. At all. What would be the point of filing a Denny motion in this particular case if they hadn't investigated anybody and that was going to come out during trial? Because here's the thing, folks. If the case had been run the way that it's supposed to be run, meaning that they had investigated everybody and it just so happened that the strongest evidence pointed towards Stephen Avery, then I could kind of understand it. But when you only investigated Stephen Avery and you didn't investigate anybody else, including those closest to her, which is standard procedure, the only reason why I can see them filing this motion would be because they knew that that shit would come out in court, that they didn't investigate anybody else. That's fucking scuzzy. Number 2, should the defendant be allowed to argue or otherwise present evidence of third-party liability, then the defendant be required to identify with specificity the individual or individuals responsible for the victim's death and satisfy the legitimate tendency test as discussed below. Basically, what they're saying here is that if the defendant is going to point fingers at somebody else, they need to be able to prove that that somebody else had something to do with this case. But this is a catch-22, folks, because by filing this motion and this motion being granted by the court, they were barred from being able to point the finger at anybody else, even with evidence, because this is interpretable by the fucking judge during the course of the trial. Number 3, except as authorized by the court for an order prohibiting the defendant from arguing or otherwise introducing any evidence or inference that evidence against him was planted. Why'd you need to do that, Kratz? Unless you knew that they had evidence that could prove that the evidence was planted. You slimy, greasy asshole. Ugh. Number 4, should the defendant be allowed to argue or otherwise present evidence that evidence was planted, then the defendant be required to identify with specificity the individual or individuals responsible for planting said evidence and identify with specificity what evidence recovered in this investigation was planted. Finally, that said offer of proof satisfy the legitimate tendency test as discussed below. So basically what he's saying is we don't want him to be able to defend himself at all. At all. That's pretty much it. Now I know what some of you are thinking. You're thinking, well, but he did introduce evidence that evidence was planted against him. But while he did, the judge had to allow some of it just to make it look legit. Now, this legitimate tendency test is described as whether the pro-offered evidence is so remote in time, place, or circumstances that a direct connection cannot be made between a third person and the crime committed. The problem is that there was all the fucking evidence in the world. The people that the defense was attempting to show could have had something to do with Teresa Halbach's death were directly linked to the crime involved, but for whatever reason, this evidence was not allowed to be introduced in court, despite this motion. Evidence that simply affords possible ground of suspicion against another person should not be admissible. Now, this is where this gets really slimy. When you file a motion like this in court, you have to cite other cases where this precedent was set. You want to know the case that Kratz cited to show the precedent was set? He cited Stephen Avery's 1985 rape case, State versus Avery. He used Stephen Avery's previous exoneration against him. You fucking scuzz. Oh my God. Where there is strong forensic evidence of a defendant's guilt, evidence of third-party liability does not raise a reasonable inference as to a defendant's innocence. Except for one minor problem here, folks. Kratz himself has stated on the record, not the court record, because God forbid he fucking do anything legitimately, but he stated to the filmmakers of Making a Murderer that he knew that he ran a completely circumstantial forensic case, which basically means that he knew that his forensic evidence was bullshit, but that's why he filed this motion, was to prevent Stephen Avery's defense team from proving that his case was bullshit. This document is just, oh my God, it is the slimiest thing I've ever seen. And see, I've had people from Wisconsin telling me, oh no, that's how things are run down here. And I'm going, if that's the way that things are run, then why the fuck did they have to file a specific motion for it? That doesn't make sense. If that's the precedent, that's it. But it's not. They had to file a motion to do so. And to file a motion preventing a defendant in a murder trial from pointing the finger at somebody else who plausibly could have done it, that takes away their ability to establish reasonable doubt, which is what a fucking trial is for. It is for the defense, excuse me, to establish reasonable doubt, and it is for the prosecution to fulfill the burden of proof. And that was not done in this case at all. I'm going to leave this link to this piece of shit in the description of this video. Also, don't forget, go onto Facebook, go to hashtag Justice for Bryant, and see what you find there. This directly bears on the case. Also, at hashtag Free Bryant on Facebook, you can donate to the cause of helping this young man get an attorney in order to sue the state of Wisconsin. I'm sorry. Don't forget to subscribe to my channel. Don't forget to follow me on Twitter, Mama Phoenix 6, and you can find my fan page on Facebook, Casey Martinez, aka Mama Phoenix. Thank you all very much for watching, and we'll see you next video.